picture a single piece of paper just resting on a judge's desk.
Right, a totally standard legal document.
Exactly. And at the very bottom of that page, there is a signature. Just, a few strokes of ink.
But those specific strokes are everything.
Yeah, they represent the only barrier, the only true check and balance standing between a citizen's private home and an armed raid by law enforcement.
It really is the ultimate safeguard.
It is. So imagine your entire life being dismantled, and the blueprint for that destruction is a document that 3 independent experts say isn't even real.
Wow. Yeah, it really forces you to reevaluate, well, every assumption we make about the legal process.
Right, because the authority granted by that single signature is absolute.
Totally absolute. When you look at the architecture of our justice system, we rely entirely on the premise that this document, this specific physical piece of paper, has survived impartial judicial scrutiny.
And that is exactly the mission of this deep dive into the Oki Doke.
Right, we are laying out exactly what our reporting found.
Exactly. What we found and what we believe based entirely on the physical evidence of this one foundational document.
We're keeping it strictly to the facts, the ink, the paper, the anomalies.
Because we have to remain completely impartial here. We are just looking at the physical reality of a single piece of paper. A document that was used to collect 651 pages of Instagram records.
And that collection, that's the genesis of everything.
Right. It's the very beginning of the chain. This happened way before any physical search was ever conducted.
Way before any arrest of J.T. Jackson ever took place.
Exactly. So for you listening, if you are charting the chronology of the investigation into J.T. Jackson, those 651 pages of records, they are the origin point.
Yeah, without them, the subsequent events simply do not have a legal catalyst. They don't happen.
Right. So let's bypass the basic definitions for a second. We all know what a warrant is supposed to be.
Sure.
But the mechanics of this specific authorization are crucial to understanding the gravity of the situation here.
They really are. I mean, we are talking about compelling a massive tech company to hand over highly private digital footprints.
Right. An investigator cannot just, pick up the phone and ask for those records.
Oh, absolutely not. They have to formally draft their belief, list their evidence, and sign it under penalty of perjury.
And then comes the really critical phase, right? The independent review.
Yes. The judge. Because the judge is not there to facilitate the investigation.
Right. They aren't on the investigator's team.
Exactly. The judge exists as a constitutional firewall. They have to weigh the investigator's claims against the privacy rights of the individual.
And if and only if the judge finds sufficient cause, they affix their signature.
Right.
So my question is this. If the system relies entirely on the authenticity of this one signature to authorize an invasion of privacy, well, what happens when the physical paper itself looks suspicious?
That is the million-dollar question.
Right. Like, what happens to the legal status of those 651 pages of Instagram records if that judge's signature never actually happened?
Well, legally speaking, they become poison.
Poison.
Yeah,
Wow.
literally. If an investigator fails to secure a valid, authentic signature from a neutral judge, they possess zero legal authority to compel Instagram to hand over a single kilobyte of data.
So the whole thing just collapses.
Completely. The entire structure hinges on the validity of that one specific authorization. If the authorization is compromised, the authority it supposedly grants is nullified instantly.
Nullified. Which, this procedural reality forces us to look incredibly closely at the specific document at the center of the investigation into J.T. Jackson.
We have to zoom way in on it.
Right. So the document claimed to be signed by Judge Stacey Wise.
Yeah.
And it's dated September 29th, 2017.
September 29th, 2017. Got it.
Yeah. And when J.T. Jackson's legal team obtained this document, they made a highly unusual strategic pivot.
Which is fascinating from a legal strategy standpoint.
It really is. Because most defense teams, they immediately attack the probable cause, right?
Right. They argue the investigator's reasoning was flawed or, just insufficient.
Exactly. But J.T. Jackson's team stopped at the paper itself.
They didn't even get to the argument.
No. They looked at the ink. They looked at the spacing, the physical anomalies of the actual page.
Which tells you something right away. It signals that something on that page appeared visibly and immediately problematic.
Right. Because legal teams don't just casually challenge the physical authenticity of a judge's signature.
No, never. It is an incredibly high-stakes maneuver. I mean, it implies that the document didn't just fail a legal standard, but that it failed a visual, structural standard of reality.
Wow. Yeah, a standard of reality. So before uttering a single word in open court, before filing any explosive motions, the legal team made a really critical, calculated move.
They brought in the experts.
They hired 3 completely independent handwriting experts to examine the document.
3 isolated experts. And, the methodology here is arguably as important as the actual findings.
Break that down for us. Why does the isolation matter so much?
Well, in forensic document examination, cognitive bias is a massive concern.
Okay.
If you put 3 experts in a room together, or, let them review each other's preliminary notes, human nature dictates they will influence one another.
Oh, like groupthink.
Exactly. A more tenured expert might unconsciously sway a junior colleague. Hey, look at this loop here. Don't you think it's off?
And suddenly the junior expert agrees.
Right. So by enforcing total isolation, no shared conclusions, no comparing notes, 0 cross-contamination, the legal team ensured that each analysis functioned as a standalone scientific evaluation.
That's incredibly smart, because if 3 isolated experts arrive at the exact same conclusion completely independently, well, the mathematical probability of a coincidence drops to virtually 0.
It's as close to a scientific certainty as you can get in a courtroom.
So let's look at what the first expert discovered. We're talking about Bart Baggett.
Right. Bart bagging.
This guy has a serious resume. He has examined over 14,000 documents across more than 880 cases.
That is a staggering amount of time looking through a microscope.
Yeah, and he is qualified to testify across multiple states. He's been consulted by CNN.
When an examiner processes 14,000 documents, their baseline for identifying microscopic anomalies is highly, highly refined.
Right, they aren't just reading the name.
No, they aren't looking at the signature as a whole word. They are evaluating pen pressure, stroke velocity, the microscopic dispersal of ink fibers into the paper.
Wow. Ink fibers.
Yeah.
So Baggett does his analysis, and he submits a formal written declaration detailing his findings under oath.
Under penalty of perjury.
Yes, and his conclusion left absolutely no room for ambiguity. Baggett stated that Judge Stacey Wise did not sign the questioned documents.
He definitively ruled her out.
He formally declared that these documents appear fabricated.
And, we need to pause on that word. Fabricated.
Yeah, that's a heavy word.
Using the term fabricated in a sworn declaration shifts the entire landscape of a legal proceeding. He is stating that the document presented as a foundational legal authorization is a fiction.
A complete fiction. And Baggett based this on a very specific, really damning detail.
The exact copies.
Right. He found that 2 of the questioned documents contained signatures that were exact copies of each other.
Which is impossible.
His exact words were, "No 2 people ever sign exactly the same way twice."
And he's completely right. The biomechanics of handwriting make identical replication physically impossible for a human being.
Because of muscle memory.
Muscle memory, yes, but also environmental variables. The friction of the paper, the angle of the wrist, the person's resting heart rate in that exact millisecond.
Okay, I want everyone listening to try this. Sign your name right now in your head.
Just picture it.
Yeah, picture the flow of the ink. Okay, now sign it again in your head.
It changes.
It totally changes, even visualizing it. The second attempt isn't identical to the first.
Right. The pen lifts a fraction of a millimeter differently.
Exactly. The loop of a letter tightens just a little bit. The pressure on the downstroke changes.
Humans are organic creatures. We are not printing presses.
Right. No 2 real signatures executed by a human hand are ever pixel for pixel identical.
So finding 2 identical signatures is not evidence of incredible consistency by the judge.
No, definitely not.
It is undeniable physical proof of artificial duplication.
Which extrapolates to a deeply disturbing conclusion. Because identical signatures mean digital duplication.
Right. A cut and paste job.
Exactly. It indicates someone took a legitimate signature from an unknown location, digitally duplicated it, and just slapped it onto a document submitted to a judge, swearing it was true.
And the implications of that are catastrophic for the chain of custody.
How so?
Well, submitting a duplicated signature as a genuine judicial authorization completely circumvents the protective mechanism of the justice system. You've bypassed the firewall.
You just built your own door.
Exactly.
Now, one highly qualified expert finding a digital copy is a massive story on its own.
It's a bombshell.
But, as we said, scientific rigor demands replication. So the legal team brought in Beth Chrisman.
Out of Long Beach, California.
Right. She is a certified specialist.
Yeah.
She has handled 1,600 cases and testified 130 times.
And that's crucial. An expert with 130 instances of courtroom testimony understands exactly how hostile cross-examination works.
They know they're going to get grilled.
Right. They do not commit to a finding in a sworn declaration unless the physical evidence is mathematically unassailable.
Because their reputation's on the line.
Exactly.
So Chrisman examined the exact same documents. She compared them against known, authentic samples of Judge Wise's signature.
And what did she find?
She eliminated Judge Wise as the author completely.
Wow. So a second independent elimination.
Yes. She found that one document was originally signed, but the other contained a transferred signature.
A transfer signature. Her findings corroborate Baggett entirely.
It's the exact same conclusion.
Yeah, because transferred signature is just the technical forensic terminology for what we colloquially call cut and paste. It means the ink did not flow from a pen onto that specific piece of paper. It was mechanically moved from point A to point B.
Unbelievable. And then we arrive at the third isolated expert, Kurt Kuhn.
Operating out of Forensic Consulting Services in Fullerton, California.
Right. So Kuhn does his independent analysis, and guess what? It aligns perfectly with the first two.
3 for 3.
He concluded it is highly probable the signatures were not made by the same person who authored the known signatures of Stacey Wise.
And he also noted the identical reproductions.
Yeah,
Right?
he did. But Kuhn used a phrase that removes any lingering ambiguity whatsoever. He called it machine manipulation.
Machine manipulation, that is highly specific.
What did that actually mean in forensic terms?
That specific phrase dictates that a machine, whether that's a scanner, a photocopier, or, digital compilation software, was actively used to alter the document.
It wasn't human hands.
Right. It was manufactured.
Okay, I have to play devil's advocate here for a second, because our listeners are probably wondering this too.
Go for it.
We live in a highly digitized legal era. During high-volume periods or, specific administrative workflows, courts sometimes use authorized digital signature stamps.
Right. E-signatures and stamps are common.
So couldn't this machine manipulation just be a sanctioned, albeit maybe sloppy, digital workflow utilized by the judge's clerks?
I see what you're saying.
Like, are we entirely certain this isn't just an administrative shortcut rather than an active fabrication?
It is a totally fair question, but forensic examiners actually distinguish between an authorized digital stamp and unauthorized machine manipulation.
How can they tell the difference?
Through context and physical artifacts. An authorized digital stamp usually leaves specific uniform microscopic markers, and it is applied uniformly according to chamber protocols.
Okay, so it looks like a stamp.
Right. But this isolated signature anomaly does not exist in a vacuum. When these three experts looked beyond the ink itself, the physical context of the document just destroyed the theory of a sanctioned administrative shortcut.
The rest of the paper gave it away.
Exactly. The deeper they looked at the physical paper, the more the illusion completely unraveled.
So let's walk through those. Because the experts identified glaring structural red flags that were entirely inconsistent with Judge Stacey Wise's known, authentic documents.
Let's start with the big one first. The missing official court seal.
Right, which is huge.
The court seal is the ultimate hallmark of judicial authority. It is literally the built-in secondary verification system.
Like a notary stamp.
Exactly like a notary stamp. It's designed precisely to prevent unauthorized documents from passing as legitimate.
And on the documents dated September 29th, 2017, the seal wasn't just faded.
It wasn't poorly stamped.
No. It was completely missing.
Completely missing. See, the absence of the seal severely undermines the idea that this was a routine, sanctioned digital workflow.
Because if a clerk did it legally, they'd stamp it.
Right. If a document moves through the proper channels of a judge's chambers, it receives the seal, period.
Wow. Okay, so the second anomaly points directly away from a judge's desk and straight toward a computer screen.
What did they find?
In every known, authentic document bearing Judge Wise's signature, she handwrites the dates and the city herself.
It's her physical habit.
Exactly. It is a highly consistent habit. But on the questioned documents, the dates and the city were typed in.
This is a classic behavioral deviation.
Which means what exactly?
Well, a judge processing thousands of documents develops deeply ingrained physical habits, like writing the date in a specific location with a specific pen stroke.
Muscle memory again?
Right. So when a document suddenly features perfectly typed dates alongside a duplicated signature, it strongly infers the document was pre-assembled on a computer by a third party.
It never physically sat in front of the judge for review.
Exactly. It was manufactured digitally.
Which brings us to the third red flag. And honestly, this one is just a complete structural breakdown of logic.
This is the pagination error, right?
Yes. One of the questioned documents was literally labeled page 4 of 3.
Page 4 of 3. I mean, this specific error is the absolute fingerprint of digital compilation.
It is mathematically impossible. I cannot overstate that.
It's not a typo.
No, it's not a misspelled word. How does a document with only 3 total pages possess a page 4?
It doesn't. In the physical world, it doesn't.
So how does it happen?
It occurs when a user is cobbling together a new document from existing digital templates.
Like a Word document.
Exactly. If you take a 4-page master file, delete a page to fit your current needs, but you fail to manually update the footer macro in the software.
It prints out page 4 of 3.
Exactly. It is an artifact of careless digital manufacturing.
It's sloppy.
Extremely sloppy. And think about the logic here. If a highly educated judge is meticulously reviewing a 3-page authorization, it defies logic that they would sign a page labeled 4 of 3 without noticing the discrepancy.
They would send it back and say, fix this.
Of course they would.
So let's pull back and look at the aggregate data we've gathered here.
It's a mountain of physical evidence.
It really is. We have 3 isolated experts confirming identical transfer signatures via machine manipulation.
Right.
We have a missing official court seal.
Huge red flag.
We have a massive deviation from the judge's handwritten habits with typed dates.
Another digital artifact.
And we have a mathematically impossible pagination error.
Page 4 of 3.
This document fails every conceivable test of authenticity.
Every single one.
Yet this was the catalyst for the entire investigation into J.T. Jackson. This exact document authorized the collection of those 651 pages of Instagram records.
And this brings us to a massive, just a gaping logical void in the paperwork itself.
Yes. We need to plant this fact firmly for everyone listening, because this is staggering.
It really is the most glaring issue of all.
J.T. Jackson's name does not appear anywhere in this foundational document. Not once.
Not a single mention.
Not one.
It is an incredible omission. Think about it. The legal mechanism utilized to pry open a citizen's private digital life completely fails to even mention that citizen.
So who does it mention?
That's the crazy part.
Right. The document targets Instagram accounts for users named Mr. Jude and Young Swoop.
Mr. Jude and Young Swoop.
Yeah. It specifically directs the collection of records connected to comments made by those specific accounts. But it does not name J.T. Jackson as a suspect.
Which is a fundamental violation of how these authorizations are supposed to work.
Because there's no connection drawn on the paper.
Exactly. There is no language within the 4 corners of that authorization drawing a legal investigative connection between Mr. Jude, Young Swoop, and J.T. Jackson.
The paper doesn't say J.T. Jackson is Mr. Jude.
Right. And the legal requirement for particularity in warrants is designed specifically to prevent phishing expeditions.
You have to name who you were looking for.
You must specify the exact person or premises to be searched. Using a document aimed at Mr. Jude to legally justify actions against J.T. Jackson requires a chain of unwritten assumptions.
But you can't just assume things in a court of law.
No, an authorization document is not allowed to rely on unwritten assumptions. It has to be explicit.
So because of this glaring omission regarding his name, combined with all the devastating physical evidence of machine manipulation and missing seals, J.T. Jackson's legal team made a massive case-defining move.
They went for the foundation.
Exactly. On February 4th, 2020, they filed a formal request with the court to throw out all the evidence in the case.
A motion to dismiss the entire evidentiary foundation.
Right. Think of a criminal investigation like a complex software program. Okay.
Okay, I like this analogy.
The initial judicial authorization from September 29th, 2017, that is the root certificate.
The base code.
Yes, it is the base code that tells the operating system every subsequent action is secure and trusted.
Right. So the collection of the 651 pages of Instagram records.
That was the first application executed based on that root certificate.
Got it. And the subsequent raid on J.T. Jackson's home, which took place on January 23rd, 2018.
That was an action executed entirely because of the data pulled from those Instagram records.
So everything is linked.
Every single piece of evidence gathered by law enforcement flows inextricably back to that initial root certificate.
And if the root certificate is actually a piece of malicious code,
Which it appears to be.
right, if it is a fabricated document with a transferred signature and impossible pagination, then the entire operating system is compromised.
It's all tainted.
The legal doctrine dictates that you cannot utilize evidence derived from an illegitimate source. It's the fruit of the poisonous tree.
So if the initial authorization is toxic,
The 651 pages of records are toxic.
and the justification for the January 23rd raid.
Entirely void.
Yeah.
Legally, it should not exist.
Wow. And again, we maintain our impartial stance on what our reporting uncovered here. We aren't taking sides.
We are just looking at the facts.
Right. We are looking at a factual scenario where 3 credentialed professionals operating in total isolation concluded the foundational document of this case was fabricated via machine manipulation.
And the missing seals and structural anomalies independently support their conclusion.
The document meant to serve as the ultimate safeguard against unwarranted state action was fundamentally compromised.
It really forces a harsh realization about the vulnerability of the system.
It's scary, honestly.
It is. We place immense trust in the physical paper of the court. When that paper is revealed to be a product of digital cut and paste, the presumed protections of the justice system just dissolve.
They vanish entirely. So let's recap the sheer weight of this deep dive into the Oki Doke.
It's a lot to take in.
It is. We have Bart Baggett, Beth Chrisman, and Kurt Kuhn. 3 experts independently identifying transferred, duplicated signatures.
We have the missing official court seal.
We have the typed dates replacing the judge's known handwritten habits.
We have the impossible reality of page 4 of 3.
And the absolute absence of J.T. Jackson's name in the document used to literally tear his life apart.
It's staggering.
This physical evidence, these expert reports, and these documented anomalies, this is what forms the bedrock of our reporting.
But, the fabricated document is really merely the prologue here.
Wait, there's more.
The timeline of what happens after that document is deployed is equally critical.
Okay, let's talk about the timeline.
So the raid on J.T. Jackson's home took place on January 23rd, 2018.
Right, January 23rd. And during that raid, investigators found nothing.
Nothing at all. No arrest was made.
Right. So for months afterward, J.T. Jackson repeatedly asked investigators when he could retrieve his confiscated property.
Just trying to get his stuff back.
Yeah. But it was just months of waiting in silence.
Crickets.
And then suddenly, a text message arrives from the investigator on April 27th, 2018.
April 27th, 2018.
The text simply says, "Come pick up your things on Monday, April 30th, 2018.
Now, to a civilian, that reads like the bureaucratic conclusion to a fruitless investigation, right?
Like, we didn't find anything, come get your laptop.
Exactly. But on the exact same day that text message was sent, April 27th, 2018, a separate event occurred at the investigator's office.
An entirely distinct delivery.
Yes, a package arrived at their location.
Just a random package.
Package signed with just 2 words. El Jefe.
El Jefe.
Yeah.
Wow. So what waited for J.T. Jackson when he walked through the doors of that office on Monday, April 30th, 2018? Well, that is the subject we are going to unpack in episode 4.
The foundation has been laid, the text has been sent, and El Jefe has arrived.
We started this deep dive asking you to picture a single piece of paper and the signature that acts as the ultimate safeguard for your privacy.
The firewall.
Right. And we end with a question to consider long after this audio stops. If a system's ultimate safeguard can be bypassed with a simple digital cut and paste, well, how secure is the door to your own home?
It's a terrifying thought.
Pass this deep dive to someone still holding the other version of this story. New episodes of the Oki Doke drop every week.